agnostics, long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government, hug the government, love the government, hug the government, love the government, hug the government.
Welcome to The Politics Guys, a place for bipartisan, rational, and civil debate on American politics and policy. I'm Trey Orndorff, a political scientist at Oklahoma Christian University, and I'm joined by the professor of law at Chase Law School, Ken Katkin. Ken, welcome to our slowish go through the U.S. Constitution.
Yeah, it's great to be back.
Yeah, it's always fun. You know, it's been a lot of fun for me. I love doing the every week kind of the stories that are happening there. But I like the idea of kind of what we're more used to doing, which is, you know, we don't teach inside of current events. So it is fun to get into those current events and see how those are influenced by the things that we teach. But it's also fun then to kind of step back in this show and say, hey, but what are some things that you might not know if you're always doing the current event? You know?
Right.
And so having that chance to kind of understand the Constitution is a big one for me. It's one of the things, if you know, you're going to be in my introductory government class, which I know many students, they dread when they come to any school. Like, oh, gen eds, I don't want to take government. But I do really think it's important for really all citizens to have an idea of their Constitution, at least have read it, and not just have read it, but as we've seen, kind of dug into it a little bit. So you kind of know what's going on and what's happened. And so that's what we're going to be doing here in this episode today. We're going to be taking on today Article 1, Section 9 in just a moment. So, Ken, you know, we have spent a number of weeks now, and as a matter of fact, even you and Mike were able to step in when I had a moment, and we've been working through the powers of Congress, and the powers of Congress are located in Article 1, Section 8 of the Constitution. It's one of the Article 1 is the longest of the articles, in part because we've talked about Congress was viewed as being the most important of the institutions in the federal government. But then immediately after these grants of powers, and it ends with the necessary and proper clause in Article 1, Section 8, we then move on to Article 1, Section 9. And that's what we're going to start taking on here. And these are, in fact, the powers denied to Congress. So, for example, here in the very first phrase, we're going to kind of go through this clause by clause. So let me read we're going to read each of these clauses, and then we're going to talk about each of them one at a time. And so the first one for Article 1, Section 9 is this. It says, the migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808. But a tax or duty may be imposed on such importation, not exceeding $10 for each person. Now, that's a lot of kind of veiled clauses here, but this is dealing with slavery. The idea here was that could Congress ban slavery right at the outset? And Article 1, Section 9, Clause 1 says, no, and this is kind of a good setup for what you're going to see, because, of course, you might think that's the case, because we've already talked about in Article 1, Section 8, one of the powers of Congress is the ability to regulate commerce with foreign countries, but not in terms of slavery. So, Ken, obviously, we're past 1808. We fought a civil war. This first clause, while it may be a good example, it doesn't serve much actual lifting power in the Constitution, other than maybe pointing out to those who don't recognize it the importance of slavery on the creation of the Constitution.
Yeah, I mean, the Article 1, Section 9 begins with depending whether you're a glass half empty or glass half full type person, it's either one of the most shameful clauses in the Constitution, because it actually says, even though Congress has the power to regulate foreign commerce with foreign nations, the one and only kind of commerce that Congress can't prohibit is the international slave trade, the importation of slaves into the country. That has to be allowed to continue for another 20 years before Congress can even consider using its enumerated power to regulate foreign commerce and banning the international slave trade. So that's sort of the glass half empty view of it. I guess the glass half full view of it would be to say, that this shows that even on day one, like the minute that we seated a U.S. Congress, the votes would have been there right away to ban the international slave trade. And that's why they felt that it was necessary. The slave states said, we're not going to join the Constitution. We're not going to ratify the Constitution unless we get some assurances that the international slave trade won't be banned right away, because we know that otherwise Congress would ban it right away. And in fact, as soon as the 20-year sunset passed, the year 1808 is mentioned in that clause, Congress immediately, the very first day that they could, they banned the international slave trade. So some people would say that this shows that we were really an anti-slavery country at heart, but had to make some compromises with slavery. Whereas other people would say, well, no, we actually, protected slavery in our Constitution, even against initial early democratic change through legislation.
Now, of course, the glass half empty side is to say, well, the reason, you might immediately say, oh, wow, there were a lot of individuals against slavery, but there were economic reasons why individuals might want to vote against that importation that would not have included ending the slave trade, but rather making their own property worth more money.
That's true, because this is only a ban on Congress is going to be given some power after a 20-year sunset to end the international slave trade. And arguably, Congress could have even used its power to regulate interstate commerce, to ban the interstate slave trade. But the Constitution, as understood by the framers, would never have given Congress the power to ban intrastate slave trade. So if you start banning, bringing in more slaves, it does raise the value of the slaves that are already here, which I think was your point. Yeah.
Now, today, of course, this is it's useful for understanding that mechanism. But again, as you noted, it has more to do with understanding the Constitution as a moral document than it really has any kind of meaningful continued legal significance.
Yeah, but that's what it's just that's right. I don't think we're in too much danger today of Congress legislating to permit the international slave trade again. In fact, we have the 13th Amendment now, so that would actually be unconstitutional. All slave trade is unconstitutional after the 13th Amendment.
Exactly. I want to get there as we move forward. Now, so the second clause of Article 1, Section 9 is this. It states, the privilege of the writ of habeas corpus shall not be suspended unless, when in cases of rebellion or invasion, the public safety may require it, end quote. So now, habeas corpus, this is one, I don't know, maybe listeners have heard of, but you don't recognize it. But it's this idea of you got to produce the body. You can't be held without having some kind of presenting before a judge. And it actually goes back to the Magna Carta. It's kind of the first location where that happens. The idea is that you can't have Congress, in this case, locking individuals up without the ability of them to be before a judge. So that's a pretty important one, Ken. What should we know about that?
Well, one thing is about the habeas corpus clause. It's one of, there's several examples you'll find in the Constitution of how the framers were not perfect drafters, because although Article 1, Section 9 does prohibit Congress from suspending the writ of habeas corpus except under certain circumstances, they actually forgot in Article 1, Section 8, or in Article 3, perhaps, maybe it would have belonged there with the judicial power. But there's no part of the Constitution that authorizes the grant of the writ of habeas corpus. Right. There's just a limitation on when it can be suspended. So, so I think that's a drafting error. But certainly the framers obviously thought that courts had habeas corpus jurisdiction, which is a jurisdiction that English courts had, as you said, since the Magna Carta. And the concept of it was that as a protection of civil liberty, if anybody was being detained or jailed or just not free to walk around, they had the right to go into a court and challenge the authority or the jurisdiction of the detaining authority to detain them. So, this went back to, the days of strong monarchy in England. And, one of the early kinds of civil rights that at least the English aristocracy was able to obtain for itself was that the king should not be allowed to just arbitrarily jail people, but that if the king, grabbed somebody, had them arrested and jailed, maybe holed up in the Tower of London or something, that there
Just
should be
for
a
an
right,
example.
just for an example, yeah, that there should be, people should have a right to petition a court, and then the habeas corpus, as you said, bring me the body. The king's men would have to produce that person who was being detained at the Tower of London. They'd have to bring that person into court and answer the petition and explain, by what authority and for what reason are you locking this person up? And if the court concluded that there was not a valid, lawful reason to justify the detention, or the detaining authority actually lacked authority to even authorize the detention, then the court would, right there in the courtroom while the detainee was there, would order, they would grant the writ of habeas corpus, and that's a court order ordering that they be set free, that they could walk right out of the court right then and there. And we have that privilege to this day, and it is primarily used, probably these days, primarily used by people who've actually been convicted of crimes and they're being held in prison. But they will argue to some extent that there was something unconstitutional, either about the law that they were convicted under or about the conduct of the trial, that the trial didn't meet constitutional requirements. So that's how most modern petitions for habeas corpus come into court. But there also have been other uses for them in modern times. And, the writ became very important during the war on terrorism when you had all the detainees at Guantanamo and elsewhere. That, again, the writ of habeas corpus was the basis for those detainees to challenge their detentions, and they did have some success at the Supreme Court. In fact,
well, I'm going to pause you for just a second, Ken, because we need to take just a moment. Okay, so Ken, when we were a moment ago, you were talking about how the most recent incarnation of invoking habeas corpus had to do with Guantanamo Bay, right? So we have this location where we're holding enemy combatants, at least under the language of then President Bush, but then not allowing them to have the normal trial process, and therefore asking to be in front of a court. So maybe to extend the idea of that Tower of London, hey, you've got to bring people from Guantanamo. They get to be with their lawyer, and they have to become in front of a judge and talk more about that now. Yes.
Yeah, so I would say nothing was normal about the war on terrorism because, one other kind, a lot of detention, as you sort of suggested, happens because someone's been accused of some crime or convicted of some crime. But in war, people are also detained as prisoners of war, right? So just the mere fact that they're members of an army of a country that we are fighting a war against, they're captured so that they can be removed from the battlefield. They're held for the duration of the war. They don't have to be accused of having done anything wrong. Just the mere fact that they're taking up arms against the United States justifies holding someone as a prisoner of war. But what happened in the war on terrorism was, the Al-Qaeda attacked this country, and our Congress authorized the use of force in retaliation. And we had a sense that the Al-Qaeda attacks had been launched from Afghanistan, that Osama bin Laden was in charge. We probably knew a few other people that were involved. But by and large, when that all happened, the U.S. Armed Forces and the U.S. intelligence services didn't really know, who all the people were who were in Al-Qaeda. And when we went over to Afghanistan and even some other countries in that region, and the mission is, round up everyone in Al-Qaeda and take them prisoner of war. We didn't have very good tools for figuring out who it was that we were trying to round up. And probably the most common tool that we used was reward money. So you'd have U.S. military or intelligence personnel going around to areas where it was thought that Al-Qaeda operated and saying, we'll pay bounties to people who tell us who's in Al-Qaeda. And so that led to a lot of people taking money and naming names, and about 800 people total being rounded up. And as you could expect from, using that kind of intelligence gathering, the large majority of them were completely innocent and had nothing to do with Al-Qaeda. And so this led to a situation where you have all these people grabbed out of Afghanistan because their neighbors decided to make a few bucks by saying that they were in Al-Qaeda, and they're brought to
we all have that
Bay.
Neighbor, let's be honest.
Yeah. They're brought to Guantanamo Bay in Cuba, and they take advantage of the writ of habeas corpus, and they start filing petitions in federal district courts. And Congress was not crazy about the fact that the habeas corpus mechanism was available here. And Congress actually passed a series of statutes between 2003 and 2007 trying to cut off the use of the writ of habeas corpus by these Guantanamo detainees. But the Supreme Court kept saying in a series of cases, the final one being a case called Boumediene versus Bush, that the privilege of the writ of habeas corpus shall not be suspended by Congress, because that's what it says in Article 1, Section 9, and that although there is a safety hatch in Article 1, Section 9, that the privilege can be suspended when in cases of rebellion or invasion, the public safety may require it. The court found that by 2007, when the last of those statutes was enacted, 6 years after September 11th, that we were no longer in a time of rebellion or invasion, and Congress had not made the finding that we still were. And they did not allow a suspension of the writ, and they actually ordered the military to give review proceedings called combatant status review proceedings to each of the detainees who wanted to make a claim that they were not members of al-Qaeda and they'd been wrongly identified. And the court also said that if those detainee proceedings, the combatant status review proceedings, didn't proceed in a timely way or weren't fair enough, the courts, federal district courts, would still backstop that using the writ of habeas corpus. And in the end, I think the way the numbers broke down, out of the 800 or so people that were ever detained there, 40 of them remain in detention today. And I guess we can assume that those people were real al-Qaeda members. Yeah. But of the more than 700 who were grabbed, all the rest have been released by now. Some of them were released into the custody of other law enforcement of other countries, so they weren't completely exonerated. But there were no more than about 100 that fit that category. I'll have to admit there were also some who were released who then joined, did more terrorist acts afterwards. Right. So they were wrongly released, I guess, but or radicalized while they were detained. But that ended up being about 80 of them. And so I think under the most generous count, if you say, well, everyone that's still there, plus everybody that committed acts of terrorism after they were released, plus everyone that was released to the custody of other countries that were going to keep them in jail, that still only adds up to about 200 out of the 800. So I think it is about 600 at least who were wrongly detained, who were found to have been wrongly detained, who were let go, and who never caused any problems again after they were let go. And a lot of them might still be there if it wasn't for the privilege of the writ of habeas corpus. So that played an important role in trying to restrain the war on terrorism to certain kind of rule of law principles. And as I say, the other kind of very common use of habeas today is it'll be used by people who've been convicted of crimes, generally in state courts, and they'll say, well, the state trial did not meet constitutional standards. And sometimes the federal courts will take a look at that, although the success rates on those kind of petitions are very low, like less than 1%. So most petitions for habeas corpus that get filed by people convicted of crimes in state court, the court will have a proceeding on them, but they won't generally grant those petitions except in very special cases.
Now, in the case of the 800 you were talking about, of course, we did have the one who was a U.S. citizen, Hamdi, right, who gets sent originally to Guantanamo because officials didn't recognize he was an American, but he also doesn't he have a similar case? Now, eventually, though, Hamdi, he renounces his U.S. citizenship and I believe still lives in Saudi Arabia.
Yeah, the other thing about his case that was interesting was it was a 5-4 vote, but the majority in the court actually did not think it was significant that he was a U.S. citizen. So the majority said that the same exact rules apply to U.S. citizens as to non-citizens. Again, that rule being that everyone in Guantanamo, in his case, he wasn't in Guantanamo. He was when they found out he was a citizen, they brought him to a naval brig in Virginia. But even for him, everyone, whether they're citizen or non-citizen, they'd be entitled to have a administrative combatant status review tribunal hearing before a military tribunal, where they could argue that they were not actually members of Al Qaeda. And so he was entitled to that, but so were all the non-citizens, and those would be backstopped by potential availability of habeas corpus in federal court if the combatant status tribunal didn't happen or if it didn't unfold fairly. But there were 4 justices who thought that was not an appropriate mechanism for a U.S. citizen, and Justice Scalia had an opinion where he said, if the government believes that a U.S. citizen took up arms against the United States, then the government should charge that person with treason, or they should let them go. And they shouldn't just be detaining them on the theory that they're an enemy combatant. And so that opinion was agreed to by 4 justices. But the majority actually in the Hamdi case found that the same exact procedure should apply to him as to all the others. And that actually included the procedure that, if the military tribunal concluded that he was a member of Al Qaeda, then even though he was a U.S. citizen, they could just continue to hold him as a prisoner of war in a military brig rather than trying him with a crime.
Well, I'm going to pause us there, Ken, because we have just reached the end of the preview, a little bit longer of a preview. I hope you guys enjoyed for our Article 1, Section 9 Constitution take. So Ken and I, we've been going through the U.S. Constitution. And so if you would like to listen to the rest of the show, if you'd like to join us for all the rest of the shows and maybe even catch up, we're already all the way to Article 1, Section 9. You can catch up as one of the fun things about doing it this way. And you do that by becoming a supporter. And that's what makes this podcast work. So if you'd like to get the rest of this, and not only this, but get ad-free versions of everything we put out, in addition to the rest of the show, all you've got to do is take a look at the show notes or head to patreon.com/politicsguys and support us. Or you can head to, for Venmo, you can hit us up at politicsguys. And of course, also through PayPal at You're going to see all of these in the show notes, as well as heading to politicsguys.com/support. If you're not in a position to financially support the show, we get that. And so you want to hear the rest of Ken and myself, please just send Mike an email at mike@politicsguys.com, and I know he will get you set up. And don't forget, if you do it through Patreon, there is the ability to do this as a free preview. So you can do it for a month. It's kind of a risk-free trial. You can take a look at that again. Take a look at the show notes. And you can go to patreon.com/politicsguys. Now, whether you're a supporter or not, we'd love for you to share this or other pieces of the preview or full weekend episodes that come out. You can either have them ad-free. Again, if you're a supporter, we encourage you to do that. If you've got any kind of questions for myself or for Ken, you want to know more about the Constitution or anything else we've talked about, you can always reach us at mail@politicsguys.com, or you can reach out to us on Facebook and Twitter. You'll see all of those links in the show notes. Also, don't forget, if you're a supporter, you're going to have the opportunity to talk to us on Discord directly, and I've been doing that earlier today, as a matter of fact. So I look forward to chatting with you in one of those ways. The executive producers of the Politics Guys are Bruce Johnson, Wilma Marino, Andra Masker, Daniel Toe, Ryan Beasley, Don Oglesby, and most recently, Ivan English. We'll be back with a new episode this weekend. I hope you'll join us then.